The proceeding will start shortly.
Welcome to this session of the Justice Committee. A particular welcome to our witness, the President of the Family Division of the High Court, Sir Andrew McFarlane. Very grateful to you for coming, Sir Andrew, to assist us. Just have to deal with any declarations of interest. I think it's only myself. I'm a non-practising barrister, former consultant to a law firm. Don't think anybody else has any relevant interests. Well, Sir Andrew, thank you very much, as I say, for coming to join us. You've been a specialist in family law for a deal of time at the bar, and then as a judge.
It wasn't an area of law I wanted to practice in when I started. I've been a barrister since 1977, but I thought, why would anyone want to do family law? Then I started 5 or 6 years in to do some adoption cases, and I thought, wow, this is pretty striking stuff, and I became interested in the law and the human interest side of it.
Yeah, and you've been president of the Family Division since 2018 now.
It's nearly 6 years.
Nearly 6 years. Well, looking at that level of experience and the current work which you do as head of division, how would you assess the current state of health of the family justice system as of today? And how's that changed, perhaps, as well?
But it's changed. It always changes. That's obviously a complicated question. Can I address it in one or two parts? And
yes, of course.
First, to say something that may not come up elsewhere in the evidence, but I think if you were asking judges, they would say, first of all, that there's a deal of apprehension about security following the striking incident at Milton Keynes Court in November. I'm obviously not going to say anything about that incident, but the fact that it happened and the security arrangements were breached to a significant degree has had an impact right across the system, and civil judges as well. And I think judges think, well, it could have been me. The issue has been taken extremely seriously by the Lady Chief Justice and the Senior Presiding Judge and by me. And we're working through what the ramifications will be, what changes need to be made, because it's quite striking that this difference between the security arrangements in a criminal court and those in a family court, where often domestic abuse is an issue, and not frequently, but not out of the ordinary, some people become very excited by what's going on, and some people lose control of their behaviour, and it could happen in any court. So that's, I think judges would have high in their view as the current state is an apprehension about whether we should carry on sitting in the way that we do. So the jury's out, as it were.
Indeed. Did you get a sense that there's been an increase in such incidents?
I think over time, if we're measuring it over decades, I don't think any judges were surprised that something had happened in a court, because that sadly is something that does happen. I think people were surprised by the degree to which the arrangement. This was a known. This was an individual who had not behaved safely before, and some arrangements had been made, and yet it didn't protect the judge. And of course the court staff are vulnerable, and indeed the lawyers in the room, and the other, if there wasn't on this occasion, but if there's another party in the room, they're vulnerable. So I think it's something that rightly has been taken really seriously, and I don't know that it would crop up in other questions, so I thought I'd mention that.
Well, since we're displaying it, are you satisfied with the level of support that judges are getting from Her Majesty's Courts and Tribunal?
Yes.
So, for example, in reviewing these arrangements.
They too are taking it very seriously.
They're fully engaged.
And so we wait, and they're working with the Senior Presiding Judge and the Deputy Senior Presiding Judge to work through inevitably protocols and templates, and then there'll be training, and I think the world won't be the same. But with the volume of cases we have is such that it's very hard to understand what we would do if it involved a wholesale change for every single case.
Yeah. And part of the whole idea, as I understand it, as you know, I was a criminal practitioner at the bar, but I do get the sense it was quite deliberately and for good reason an attempt to make family proceedings more informal, less perhaps shall we say, potentially oppressive to parties, make them more at their ease. But that
we're now
was
used
with
to
it
having,
a consequence, perhaps.
Yeah, we're used to having special measures in place for domestic abuse victims, and it's now post-COVID. It's common for people to join remotely,
yes, indeed,
physically. safe, and that's clearly a good thing from the safety point.
The only thing I was going to pick up on that point, sorry I interrupted you. No. And I just noticed that you've announced a pilot where family division judges in some circumstances will be sitting in wearing robes again.
Yes, it's a very limited pilot, and it grew from the judges at the Central Family Court, where the degree to which incidents happen is relatively high, and there's a high level of confiscation of knives at the door, not because people are trying to deliberately bring knives in, but I think in the population, at any one time people have knives with them. And so the judges felt that they wanted to do something to see if it would change the perception of those attending court as to the seriousness of the court process and the anonymity of the judge's role.
Indeed.
By bringing back robes. And so it's limited just to that court, just to 3 months.
And we'll see how it goes.
How it goes. And it doesn't require the solicitors and barristers to robe. It's just purely
for the judge, yes.
Degree of solemnity to the process.
Yes. Okay, well, that's very interesting. We'll look forward to that.
The second thing, and it's the only other thing I'm mentioning under the heading of what judges would be particularly concerned about, is the level of staffing in the court. You'll know that the digitisation programme, reform programme, bringing in computer software to undertake all the administrative tasks in the court is rolling on. And what the judges, I think, would want is to have some clarity looking long-term as to what the court of the future would look like in terms of what staff will be in the building to undertake administrative roles rather than the judges having to take their time, which to a degree they are at the moment while these computer programs settle in. And it's to be paying a judge's salary to people, judges, to be undertaking administrative roles is clearly a very expensive thing to do, and the judges need support, and so there's a worry that the level of staff may be reduced below that which is necessary to run a proper system, and so that's a constant matter, and it would be disingenuous for me to answer your question about the health of the system and not report that's
exactly. And what steps are being taken to address that concern?
Well, we're in constant discussion with HMCTS, and HMCTS have reassured the Lady Chief Justice that the staff won't be reduced to achieve benefits from the reform programme until those programmes are actually producing a situation where you do not need staff now to do what they were doing before, and also similarly to leave sufficient staff to run a proper system. So I'm comfortable that we're in conversation with HMCTS, but equally I'm entirely understanding of the judge's apprehension, because it's a proper question. What will the court look like once this is all finished?
Workload does seem to be a particular issue for the family judiciary.
It is. So to answer your question more broadly, and what's the state of health of the system, I think the word I'd choose is convalescing. I think it's been in intensive care. After COVID, we inevitably lost pace, and the backlogs went up. And the bulk of our work is to do with children, public law, child protection cases, or private law disputes between parents, and both of those rose, and we've had initiatives on each side to try and get them down, and that we may come on to data in due course, but that's moving in the right direction. Enormous resources are used, but no, it's helpful. I'm no good on numbers or working out what a number looks like, but last year we sat, that's the word, 99,000 judge days in the family court. That's not including the magistrates' days. And I was in the Principality Stadium in Cardiff last week. Looked out on the pitch. It's enormous. The capacity of that is 72,000. Wembley, I think, is 90,000, so that's equivalent to 99,000. The O2, only 20,000. The London Marathon was 50,000 people. So 99,000 judge days is an enormous amount of resource. And I wonder if there's something wrong with society that the family court is sitting that much more than the civil court. B, I hear frequently of people who've had unfortunate experiences in the family court, and there are complaints about the way the court runs, and those are legitimate complaints, and I take them very seriously. But it has to be seen against the overall scope of every day, how many court doors are opening and how many judges are sitting. So that's helpful. So there are green shoots. The big, before I close the door and go out at the end of the afternoon, the one thing I want you to, if I can, hear me on, we'll come to this again in more detail, is the Pathfinder.
Yes,
court.
yes, we will take some of that.
Although we've achieved some change, some green shoots with the initiatives that I've taken on and others have as well, this has been tweaking, as it were, the current system. The Pathfinder, which we can come on to in more detail, is a total game changer. It's a different way of supporting couples to achieve separation and agreement about the arrangements for their children in a way that entirely acknowledges any domestic abuse and provides a safe way forward if that's there. And I think that's significantly different. It reduces the resources enormously. The cases are completed very quickly, and the court is able to get on with those cases, the few of them which do carry on being contested, or turn its mind to public law.
That's interesting. That's helpful.
So can I do two other little headings here? Then I'll subside, and you can. But if I just really set the scene, transparency. Talking about the health of the system, the transparency pilot so far, and I don't take anything for granted, has achieved positive results. I think that there isn't a lot of reporting. There aren't a lot of journalists, but those that have reported accurately, and I think the public who've heard and read those reports will have learnt something about what we do, which is good. It's now live in effectively half the family courts in the country, and the ambition is for that to be completed for all the courts by the end of the year. I suspect this committee will have understood that the amendment that Harriet Harman MP introduced last week to the Jades law arose because of a report by Sancha Berg, who had observed the court in Cardiff. So I'm really pleased that that sort of thing is happening. It's just sort of a sequence of events that you'd want. Then the final thing is FDAC, the Family Drugs and Alcohol Board. This committee will know what that is, but I've learned, as I've gone around, that it's a mistake to think that the D and the A only stand for drugs and alcohol, which they do. Every case that they deal with, I think, they tell me, includes domestic abuse. There's a domestic abuse component in someone who has become a parent in a relationship which is also characterised by drugs or alcohol. And the FDAC has found a way of supporting that victim to deal with the fact that they may have a series of abusive relationships that they've gone through, to break the cycle. And I'm keen that we somehow, I'm not trying to be an advertising executive, but use the DNA, or the DA in FDAC for domestic abuse as well, even if there are no drugs or alcohol issues. And I think that's, we've learned enough to see that if we can get a parent, often a mother, at an impressionable stage, namely the start of care proceedings, it's an opportunity to break a cycle which might not otherwise be broken.
So that's a very helpful overview.
I'll subside now.
That's very useful, thank you. You mentioned the backlog, obviously, and I will just press a little on that. What's your assessment of the size of the backlog? Because there is a difference between public and private family law cases, isn't there?
There is. I mean, I've got some figures. I don't want to bombard the committee, but I'm very happy to supply.
Of course, yeah.
What I've got. The back. I'm going to give just four years.
Yeah.
Snapshot. We've got them monthly. So this happens to be August. So August 2020, the backlog for private law was over 51,000. August 21, not surprisingly with COVID, it went up to 52,800. August 22 down to 50. Then August 23 it was 46 100,000, and now February it's 45. So it's not an enormous change, but it's certainly going in the right direction. This is a lot of cases. Each case has 2 or 3 children.
There seems to be a discrepancy between public law cases and private law cases.
Yes, there is.
And why is that?
Well, they're different. The public law cases inevitably involve, because the stakes are quite high, the local authority are often looking to remove the child permanently from the family. It often involve some expert intervention, either, and there's 2 questions in public law cases: what on earth's happened, and what on earth are we going to do about it? And there's often potential for expert evidence there. That takes time. And often the end of the case is stalled because there's a need to look at the placement options for the child if they can't go home. And no matter how often you say to parents when they come into the court at the beginning, now's the time to tell us about Uncle so-and-so or Auntie so-and-so or Granny who might step forward, inevitably, human beings being what they are, the family don't step forward, then someone comes forward. So the more local authorities can look at that before they start or at the beginning. But there's the different dynamics in play in public law. The backlog in public law is more it effectively at the moment it's gone from 12,400 beginning of last year to 12,900 now. So that's depressing because we've had the relaunch of the public law outline, which was a template for case management.
Yep.
That I've got some figures on that which actually show the ones that have finished are in fact in a better shape than the average.
Right. Perhaps you're able to provide us with that data afterwards, so to say.
Yes, I don't want to bombard you with...
That's fine. I know you've got your office very efficiently. Provide us with that. That's very helpful.
My hope is that the trouble with backlog is that the bigger it is, the more turgid the whole thing is to get through. And once courts start getting into the backlog and clearing it off, then they become quicker at doing it. And we've had... we're just starting the Pathfinder at Birmingham and Cardiff, and each of those 2 courts had substantial backlogs. And in order for them to be able to start the Pathfinder with a relatively clear runway, they were given some extra sitting days to address it. And they found that by having a deliberate programme of getting the old cases in, they were surprised that the cases in fact had either sorted themselves out or were able to be sorted out relatively quickly. And we've learnt from that, and there's no reason now why every court shouldn't be doing what they've just done, whether they're going to get the Pathfinder or not.
Are there regional variations in terms of the backlogs and delays?
Yes. Partly, as the committee will know, we've got a shortage of salaried judges in the South East and in London, and so the backlogs in London particularly are higher. It's in the smaller courts, the difference of one judge or not one judge makes real difference, and so there are variations.
Yeah. And do you think you have access to enough data to be able to track that sufficiently from your point of view?
Well, no, I think you can never have enough data, and I think anybody in our system would say that the computer system at the moment that the service has, which is called Family Man, family management system, not meant to be a pun, but it's called Family Man, is now very antiquated, and it counts things in pretty lumpy amounts. And so we look to the time when the new reform products are in, and we can count things more in a more agile way. CAFCAS have good data, so we tend to use that.
Use that, yeah. And your new systems should be in place by when, do you think, with the reform programme?
I think we have to wait to see that the private law programme hasn't started yet, so I'm going to put...
It's difficult to predict it. Predict at the moment.
On a date, yeah.
You talked very positively about the Pathfinder programme. I know there's been some other initiatives that you've launched as well, the Make Every Hearing Count guidance and, as you said, relaunching the public law outline, try and speed things up. What's been the success with those initiatives as well as Pathfinder?
The public law outline, again for members of the committee, was introduced when Parliament passed the statutory requirement for public law cases to be undertaken within 26 weeks.
Yep.
This was a new focused way, and effectively the message was the court only decides whether the threshold criteria for intervention is met, what the care plan is for the child in the bald terms, going home or not, if not to the family, if not to adoption, and then makes the final order as to what's been affording the child's welfare paramount consideration, rather than, as had been the case before that, the court hanging on to wait for the care plan to be finessed in every detail. Which school's the child going to go to? Which doctor would have been instructed for this work? What's the placement going to be? And that was very successful. It came in 2014-15, and by 2016 the national average was 27 weeks, which had come down from around 60 when the Family Justice Review reported. But then, and I don't want to give you the whole minute spiel on this, but then, out of the blue, the volume of incoming work went up by 25%. And my predecessor, Sir James Mumby, memorably said, we don't know why this has happened and we don't know what we can do about it. So we then started looking at that. And by then I was president, I set up a group, the Public Law Working Group.
Yeah.
And we came up with proposals for local authorities to really tighten up their decision making before they decided to come to court.
Right.
So, and that did produce a drop of about 13%, which has been sustained in the volume coming in. The PLO, however, with COVID, people got out of the habit of sticking to it because it was very difficult to have effective hearings when COVID was around, to get everybody to file their statement, the expert to do their report, the social worker to be present and well, the parents were present and well. Hearings were adjourned, and the courts got used to delay, and it became normalised, and so they stopped connecting with the 26 weeks because it just, the experience was you never achieve it. So what I did was to kick-start the PLO and say, look everybody, that's only going, if we carry on like this, it's only going to carry on spiralling.
Indeed.
And that message really got home, I think.
You've had the buy-in from practitioners.
Yes,
for that.
Everybody. I mean, of course, I would say this, but I do think it's true. I think they got it, and I think they are doing their utmost to adhere to it, because that's the way to address it. It's unconscionable for young children to be waiting in interim foster care for even 6 months.
Indeed.
6 weeks, but for longer, while the grown-ups, us, their parents, local authority work out what to do. I think, and as I say, the thing is moving in that direction. I've got
right.
Got another set of statistics. This is care proceedings that have closed within 26 weeks.
Yep.
So if the measurement was taken in Q3, so that for us is the autumn of 21-22, so it's going back to post-COVID time. Only 22.8% of cases finished within 26 weeks. And then the following quarter, it went down to 18%. Whereas the year, skipping forward now, 23-24, so the year that just finished, Q1 was 25%, Q2 27%, Q3 31%, and the next quarter, the final one I anticipate will be higher. So the direction of travel.
Right. How long do you think before we get to about nigh on 100%, or as near as we can?
Well, the question, time to ask that question is probably July or August, when we've had the bulk of, there's a whole bulk waiting to come.
Okay, so that'll make a difference.
And that's where we want to get. We all want to get there, but it's not a perfect system.
Well, that's helpful to have that time frame. Dr. Mullen.
Thank you. Sir Andrew, you mentioned the Pathfinder pilots, but I want to kind of go the step before that in terms of the suite of measures that the government's introduced to try and reduce the likelihood of family custody disputes ending up in court. Firstly, just your observations really on why it's commonly described that we think these things are getting worse and more people are ending up in a legal dispute. Do you think that's true? And if it is true, why do you think there is this trend towards more custody disputes ending up in court?
I think it's complicated. I think there are more people, which is an easy answer. I think, without making a political point, but I think the statistics show it. When legal aid was taken away from this private law work, the volume initially dropped quite substantially, but since then it's gone up, and an awful lot of the cases are litigants in person. And you've mentioned the government proposal, I'll come on to those, but you can picture the scene. If you separate and you can't access, without coming to court, parenting programs or professional input of any sort, and you can't actually access much independent authoritative advice. If you Google, if you're a man, Google if you're a woman, you might get hived off into different interest groups. So people come to court, or maybe if you go to the police or social work, it's a domestic, you need to go to court. So I think we've seen a rise for all sorts of reasons of that sort. And I and others were pushing for some action to be taken by government. It's not for judges to tell government, but our frustration was that we can't connect with those individuals until they've issued a court application, because we don't know they exist, and it's not for the court to be putting out messages generally to the public. And so I think a fair proportion of the people who come would be better off not coming to court, and if we can get that message across. Some people really need to come to court. They need protection, and I'm absolutely keen for them to come. So to go, you mentioned the government proposal. I was very keen. They were encapsulated, I think I mentioned it when I was here before, in something called What About Me, a report that pulled together really all of the resources that might be thought of to support separating parents. And it was Dominic Raab MP, when he was Lord Chancellor, who picked this up and consulted on a range of proposals which eventually have come out into the policy announcement in January. So I certainly welcome this, because I think that's going to be of real benefit to parents and help them not come to court, but sort their problems out in a sensible and sustainable way.
And across the measures, it's things like early information, early legal advice, mediation. Which do you think has got the greatest potential to divert people away from a courtroom?
Well, I think the whole thing, that what's needed, and this is a big ambition, is for there to be a change of mindset in the community that looks at these options as a range of options, and what suits one couple won't necessarily suit another. So I don't think there's any one of them which is my top pick. I think they're all good. And for example, the parenting course is something that a group of parents go on. So if you and your ex are both going on one will go to one course on a Tuesday, another will go to a different one the following week, different parents. But it's a bit like a speed awareness course for parents. This is what's happening, you're separating, these are the options, this is the impact on children generally. Have you thought about this? And that's really sensible input, and it allows parents from other families in a similar spot to talk to each other. So I'd have thought that's innovative. At the moment we do that, we can order it in court, but it's not available until you come to court. So it's none of this is of itself a silver bullet, but it's all, I think, very much in the right direction.
Some of the discourse around mediation has been a question of whether people should be compelled to have attempted mediation, and some people argue that if you're being compelled to do it, it doesn't really kind of meet the approach that you might need for it to be successful. I think you probably are of that vein as well. Am I right in reading what you've said previously about it?
Yes, but as you know, it was part of the government consultation, but it didn't travel through to the policy document. It depends what you mean by compulsion, and I think the court now, the rules are changing at the end of April, and for example, the court can, instead of forcing someone to go to a mediation, information and advice meeting, the court can say, well, we're not going to have any more court hearings until you've been.
Right.
And so that's compulsion. But in fact, it's perfectly sensible, it seems to me, that people have tried alternative means. And that happens in civil litigation as well. So compulsion is perhaps the wrong word, because it may send a rather clunky signal that it's compulsion, whereas in fact you can require something or expect something firmly.
Yeah. Okay. And outside of compulsion, what do you think are the other ways we might encourage separating parents to make use of these services that are available?
I think signposting, the digital process, where people have to fill in a form online, and we're all used to this. We get bombarded with it in other contexts. When you're trying to book a holiday, you get. It's possible to signpost people within that. Looking more at long term, the Online Procedure Rule Committee, which the Master of the Rolls chairs and I'm on, doesn't allow people to even get to making the application to come to court for family, for anything, without going through an online experience where they are...
That's the currently it doesn't...
That doesn't happen. This is something that will come in 2 or 3 years' time.
Why 2 or 3 years' time? That seems like a very obvious...
It's taking... what I'm describing, the Online Procedure Rule Committee, is a wholly new concept, and it's being worked up quite quickly, but it needs to be worked up in detail, taking in the whole of civil and family law. But we can be doing stuff, I think, in our digital space to someone's applying online. Only this week, with the new scheme coming in next week, together with the Ministry, I've written a short letter, which is going to go out to anyone who applies to the family court, saying, hang on, have you thought about this? There are other ways of sorting this out. I didn't actually say hang on, but that's the gist of it. So I think bit by bit...
That's definitely going to happen.
That will happen. If you apply after the 26th of April, whatever the date is, then both you as the applicant and the other party will get this letter.
Going back to the online side of things, without directing the criticism towards you, it does seem to me that isn't necessarily a hugely complicated idea, that you're doing it in letter form, that you could just put a few links on a web page. Again, I'm kind of curious as to why that's such a long...
I'm the wrong person to be asking about that. It's not a hugely complicated idea, but my experience with all of our online processes is that it takes a long time to achieve something that actually happens.
Okay. Just on the Pathfinder courts, you touched on them earlier. I think you spoke about them in positive terms. Do you have results as to what impact they're having?
Yes, the honest answer is I do, but I can't tell you what they are. The data is HMCTS data, and it's not been published yet. There is an appraisal of the Pathfinder courts. They are in North Wales and in Dorset, that the MOJ has commissioned, which we hoped would be published around now. It's been delayed a short time, but that will have the statistics in them. I can say that the Pathfinder experience is that most courts, most hearings, most proceedings sort themselves out at the first hearing, or if they have to have a second hearing, because they've got virtually no backlog, that takes place 2 or 3 weeks later, and it's short. And so it's a much tighter process.
And have you found it successful for managing even kind of conflict, setting aside, as you said, those scenarios where you need some kind of form of protection for any of the parties, but setting those aside, high conflict situations, have they been successful in?
Yes, and in the 2 pilot courts, every case goes in. They don't triage and take the high conflict ones out. My primary concern, I think, when I heard about the Pathfinder, was that if it was dealing with the cases and looking to achieve a consensus at an early stage, it might avoid considering the domestic abuse side of cases. 60% or more of the cases domestic abuse. But I've asked and asked about that, and I'm now reassured that it does, because part of the focus, I'll step back and tell you, just if I may, what it does. The current model, I apply to the family court for an order about my child. I say, this is what I'm upset about, this is what I want. The other side, my wife, puts in her side and come before a judge, and immediately we've got a conflicted structure. And the judge doesn't know much about the case at that stage because there's very little information and no independent information coming in, acts more as a referee. And so the case is litigant-led. They say this is what I want, and the court reacts. And it really only stops when one or other of them accepts, or both accept, that it's stopped. If they want to carry on and keep coming back to court, and in abusive cases, quite often the perpetrator of abuse will use the proceedings. It's the whole thing is potentially harmful, but it's litigant-led. This is wholly different. One person applies, but before any court hearing takes place, CAFCAS, or CAFCAS Cymru in Wales, the social work agency that advised the court, go and see the children, go and see the parents, and produce a report of 12, 15 pages. That's the sort of information we only get 7 or 8 months down the track when a welfare report is produced in a conflicted case. The court and the parents get it up front. It's called a child impact report. So the conversation, and it's much more of a conversation at the first hearing, is with the judge saying, is this description of your dispute about right? Yes. Well, look at the impact on your child of this. What are we going to do? It's a problem-solving court. We're not concerned with who said what 6 months ago or who did what 6 months ago. What are we going to do about it? But within that, getting to the domestic abuse side, whatever you say are the rights and wrongs, do you accept that she, as it often is, she is extremely vulnerable and doesn't want to have anything to do with you communicating about these arrangements? If you're going to have time with your child, if it's safe for that, how are we going to arrange things that protect her from you? And so immediately you're cutting to what's the solution, rather than spending a long time mithering over the problem. And so my concern was that whether domestic abuse was being in some way fudged and sidelined. But another aspect of Pathfinder is that the court in these regions actively forms a working alliance with the local domestic abuse professionals, so that they regularly attend court with the families that they're already engaged with, and the court, if it spots there's a need for them, will refer cases to them, which I don't think ever used to happen in the old days. And I've now met domestic abuse workers in North Wales, in Dorset, and last week in Cardiff, and they are very positive about this, as is Nicola Jacobs, the National Domestic Abuse Commissioner. So I'm reassured by their focus, which is entirely on making sure that this is safe.
Just on the expansion, the planned expansion, I assume you view that positively, but even if you do view it positively, what do you think the risks are to rolling it out more widely, if you think there are any?
I'm very pro-expansion. To finish my sort of metaphor about litigant-led, the current model, the Pathfinder is child-led. And I think that's the key thing that makes it work. We're no longer piloting it. It was always thought to be a good idea, but it's worked so much more impressively that we're clear it's the right idea, and I'm sure this is the Ministry's view as well, because they say it in their policy document. We're trialling it in the 2 bigger centres of Birmingham and Cardiff to see what you need to do to make it work in a more complicated setting. I think there was a bit of extra money in the budget to look at going to other places. And although currently we've only got 4 places, and so what I'm about to say is odd in that respect. There are 40 court areas as opposed to the 4 we've got. We're already at something of a tipping point, because to be telling other courts that haven't got Pathfinder, this is what it's all about, this is what you do, but you can't do it, seems wrong. In Wales, it'll just be the area around Swansea that doesn't have it. So I think we're getting to the stage now where, as part of what we do, we need to be getting everybody to prepare for Pathfinder. A, because that's a good thing, because a lot of the ideas are good. B, because it'll get them to address the backlog in their courts. And C, because it'll make it easier for Pathfinder to land with them when it comes.
Okay, thank you.
Next.
Thanks, Bob. So, Andrew, thank you very much for coming along this afternoon to give us evidence. I wanted to specifically ask about parental alienation and how well the family courts are now addressing that issue.
It's an issue which always occurred in some, I mean, I'm so long in the tooth, it's something that has been around, where one parent says, well, the other one is changing the child's view of me, and it's not. And so that's been there, but there's been a complete upsurge in the number of cases in which it's alleged, and you particularly, I suspect, will know as I do that this is often fed by understanding that's given to separating parties, that if allegations are made against you, then you might counter that with parental alienation. So we've seen a real rise in the number of cases where it's alleged. It's very difficult for the court because in the end, although parental alienation is a label, it's certainly not a syndrome, it's not a diagnosis, but it's a label that's used around. But what the court needs to be doing is not so much deciding whether this is tick-the-box parental alienation or not. The court needs to be looking at what's actually happening to this child in this family. Are the parents behaving in a way which is harmful or not? Just as that would be the question if some more physical harm was being alleged or sexual abuse was being alleged. And so I encourage courts to move away from the label and simply see whether there is something that needs to be investigated in this case, and if so, to get on and investigate it.
And how effective are those investigations, and what's the level of reliance on psychologists, expert witnesses? There certainly have been significant concerns raised in regard to the quality of some of those.
There has
experts.
been concern raised, and you will know, I suspect, I presided over an appeal which raised the issue. Frustratingly, it wasn't a vehicle that allowed me to deliver any definitive determination saying that some experts should or should not be instructed. It certainly brought to light, to my mind, that the term psychologist can be used by anybody. I could call myself a psychologist. The key thing is whether they're registered with the relevant health professional agencies. And at the moment, some of the experts who are instructed in these cases aren't registered, and there's a degree of concern about them. In that case, I indicated, because I just didn't think it was the place for a judge, certainly hearing an appeal, to lay down the law to that degree, saying that a whole group of individuals can't be instructed, that it was properly a matter for either those professional agencies, the professional bodies, or for Parliament. Further discussions have taken place. It's not at all an easy topic, and the position has now been reached that it's going to go back to the Rule Committee, the Family Procedure Rule Committee, to see whether they are in a position to lay down some basic requirements that individuals have to meet in order to be able to be instructed in these sorts of cases.
Is there any anticipation of how long that might take?
Well, I think that would be something that would go to the Rule Committee now, so it hasn't been before, and so it's something like 6 months, I would have thought.
6 months from now, so
yes.
Sort of turn of the year. And the Family Justice Board published, I think it was 6 months ago, the draft guidance on responding to allegations of alienating behaviour.
Yes.
What's the response been to that?
Now I know this, but I need to have a look. It was good, and we had, I think, off the top of my head, it was 97 responses, but some of them ran to 93 responses, some of them ran to over 40 pages. It's the Family Justice Council that did it, and they are completing their review of all this, and the final version of the guidance is expected in the autumn.
When and you've expressed your concern about unregistered experts, how do you communicate that to judges in the family courts, and how have they responded?
I said as much as I felt I could say in that judgment. I've spoken at judicial training courses. My line has, and I'm happy to tell this committee, has been that it should be the norm to instruct people who are registered, and if the court is being invited to instruct someone who is not registered, then there has to be a particular reason why that is the necessary instruction rather than any option for someone who is registered.
And just finally on this, can I take you back to something you said in response, I think, to a question Sir Bob asked, that
yes,
you could argue that this was something wrong with society, that there was such levels of conflict and that parental alienation is certainly being used, or an allegation of parental alienation
yes.
can be used to weaponise relationships in family court proceedings. What role should Parliament have in trying to bring about greater levels of harmony, or should I say perhaps less ambitiously, lower levels of disharmony?
Yes, it's not. I think it would be ambitious of Parliament to legislate to produce greater levels of harmony, but the sorts of proposals that Dr. Mullen was referring to are the sorts of steps that can be taken to, where there's disharmony, to assist people to work out what they might do to avoid making things worse and increasing the level of conflict. And so Parliament, in the sense of approving resources for that approach, would be helpful. Sounds like a car salesman, but I'm so persuaded that Pathfinder's the right course, but it doesn't need law to change. The law that the Pathfinder Court applies to the cases is exactly the same, but it needs very modest resources to roll it out across the country. And the way of thinking behind Pathfinder is to avoid conflict, to encourage focus on the children, to encourage people to work out what the resolution is going to be rather than deciding how they're going to fight the fight. It is likely, I would have thought, to save resources in societal terms, and it'll certainly save resources in the court system.
I think I was taken with your comment that you wanted courts to be problem-solving courts. That's a cultural shift, isn't it?
Yes, it needs a cultural shift on our side because we're lawyers in the end, and goes back to the comparison I made between a litigant-driven process, which is we've got at the moment for these cases, and it's no surprise we have, because that's what litigation is normally about. If you're in the civil court, the parties are the drivers of the process, and the judge is the judge. Whereas I think that's helpful for families. I think what we need to be doing is something different. The judge, there's a district judge in Dorset who's running the Pathfinder there, and she, when I visited, she said, "Andrew, this is what family law should always have looked like, all the way down the years." And so I think it's different, and I think there's a light bulb moment for me, and I would hope that Parliament would also spot in the busyness of life that this is something that's of real value, that could make a real difference.
Thank you.
That's very interesting. That's very helpful. One of the sad facts is, as we've talked about already, is there is a degree of antagonism within the system. And of course, underpinning that, as you said yourself, in many of the cases now, is domestic abuse, isn't it?
It is.
Of one kind or another. That appears sadly to be growing.
Yes. Also, and this is the way life is, a very broad community of people come to court about their children, and often they're nationals from different countries, and often the way that disputes and the way family relationships are organised in those countries are different from ours, and they face a judge approaching it. And so there's a range of complexities in these cases, which it's easy to look at the statistics and say, why is this backlog so high? But behind them, there's
those sort of complexities,
a lot of frightened and damaged people, but in tricky situations.
In fact, a large number of people are representing themselves, litigants in person in the family courts, are much higher, I think, than elsewhere, isn't it?
It is. But part of the government's proposal is to pilot early legal advice, which will surely go some way to help managing expectations.
That's something you want, I think. Yeah. Looking purely at the domestic abuse aspects, since the 4 years ago, the harm panel's recommendations, a number of steps have been taken. What do you think remains to be done to ensure that where there is domestic abuse, and it has come through to the family courts, that the experience of the survivors of that abuse is as good as it can be? Because there have been concerns at one time that there wasn't the same.
Well, there are still concerns,
support,
and I there's been a campaign that was promoted in the Sun newspaper last week, and these are legitimate. These are people who've had a bad experience. And organisations who know what they're talking about, who describing a negative experience, and so you can never improve it so that isn't a difficulty. We've every single family judge who does family work in the country went through a half-day training on domestic abuse in the last 18 months, which, as well as reminding them about concepts that they will have known about, really brought home the element of domestic abuse, which is coercive, controlling behaviour. Doesn't really matter what the physical actions may or may not have been, and you can be damaged just as much by a relationship where there is no physical interaction. But moving on from that, I've been struck by the positive professional relationship that I described between the domestic abuse professionals in North Wales, Cardiff, Dorset, and the court. And I've asked around since then, and I think nearly all of the local courts have now got relationships like that with the local profession. And my aim is to make sure 100% of that. And I think it's one thing to go on a half-day training course, but if part of your regular experience at work in your court is to have domestic abuse professionals coming in and advising you, and you know them, and you listen to and respect their advice, you'll pick up by osmosis their approach to this issue, which I think, for me, I think that's a better way of interacting with professionals.
One specific thing that was done, of course, was the 2021 Domestic Abuse Act, prohibiting cross-examination by the perpetrator of the abuse of the victim, often because they'd be acting in person. We had the concept of the qualified legal representative to take on the cross-examination where that was necessary to be done in the interest of justice. It seems as if that's not been taken up very well. I think about 113 QLRs have been used in 12 months since it's been in, which, given the volume of business, doesn't seem very high. What's your take on that?
That's not the statistic I've got. The point is certainly right, that it hasn't been taken up in all the cases by any means that it should be. When it was passed by Parliament, that in so much as judges ever go and cheer, there was judicial cheering, because we'd been before that the judges have been asking the questions themselves, which always seem to be uncomfortable and potentially look to be unfair. And so this was a very welcome introduction, and it's extremely frustrating that it hasn't been taken up. Hasn't been taken up, I think, being candid for a range of reasons. The rate of pay is not a high one at all. Initially, travel expenses weren't paid. Now they are, and the Lord Chancellor has introduced that now about at the turn of the year, January, and hopefully that will make a difference. Also, because the court is so busy, the lawyers who might become QLRs are in fact fairly booked up and busy doing their own work, and so there isn't a ready pool of people to undertake the work. Also, in order to be authorised as a QLR, you have to go on a training course. Yeah, that's right. At your own expense as a barrister. It's only available to barristers at the moment. The solicitors haven't been got a training course they can go on. So there's a range of frustrating impediments to make it work.
Yes, I mean, you referred yourself, didn't you, in July of last year, in your view from President's Chambers, to the frequent and widespread difficulties that were being encountered, and dispiriting and concerning.
Yes, and the problem, I went to Newcastle in the autumn to visit the court, and I said, I've got a couple of days free if you want me to do a case. Give me whatever you want. And they gave me a case that a district judge would normally have of 2 litigants in person on a fact-finding case. So I had to ask all the questions. I had to ask the lady in chief get her to give our case. Then he gave me the list of questions he wanted me to ask her, and I asked her the questions, and then he went in the witness box, and it was a very unsatisfactory process for them and for me, but it was an eye-opener that this is what district judges and magistrates are having to deal with day in, day out. So the getting the QLR up and running, I think probably the training is that's the bit.
More than the fees?
Well, the fees, it's not for me to really say about fees. Of course, the fees would help. The Law Society are looking at providing training for solicitors, and that would be very welcome if they do.
There's been quite a lot of discussion about, in the criminal jurisdiction, for example, around pre-recorded cross-examination in sexual cases, Section 28 cross-examination. There's been quite a lot of debate there about fee levels, about how much preparation is required by the advocate, for example, to fully grasp what needs to be cross-examined.
Yes.
Do the same considerations
I think apply? They do. They think these are the sorts of cases that you're describing in the criminal court will have more paperwork in them than a typical fact-finding case. But it's not an easy... The QLR doesn't come in to represent the person. So it's quite a tricky role. You've got to know enough about the case to understand what the questions are about. But you've got to avoid being drawn into advising the individual. Yeah, no, and so
you've got to have a grip of the whole of the papers, though, shouldn't you?
Yes.
No, I get that. The only other thing that's been raised with us, I had a letter from the Chief Executive of Women's Aid, who was concerned that whatever the good intentions with the efforts to make more special measures available in the family courts, she said they're often not accessible to survivors, and that the offer's heavily dependent on the individual court, and was concerned about the level of communication that many survivors didn't know whether their request for a form of special measures, whatever that may be, or had actually been granted until they arrive at court, and they're therefore going to court in a state of some nerves and uncertainty as to whether they are going to have either a screen or a link or whatever.
Well, I certainly get that, and you can picture the scene if you are such a person. It's the court service, and it's their responsibility for doing this, really work very hard. It's individuals in the court office doing it, and special measures are requested in a significant number of cases, and one hopes that in a lot of the cases they do work. But our system is overborne with cases. It's not the most efficient system, and so it will inevitably be the experience of someone getting to court and not knowing, or the court
thinking, a presumption in favour of them,
or at the last minute, you do want special measures, then the person will feel that a fuss is being made, and it gets the case off to a difficult...
What more can be done, do you think, practically, to make that, to remove that concern that Women's Aid raised with us? or that level of concern at any rate.
I think increase the efficiency of the court system to be able to know far more robustly whether this is or it isn't. We could move to a sort of booth set up in every court where every hearing was special measures, but that I think would not be well.
Might be overkill.
I mean, one idea, and this is just an idea sitting here, it's not something that's got any prehistory, would be to have the special measures in place as the default, and then they could be removed.
I see.
And so they're much more likely, therefore, to be there on the day. So all of this is resources, and when you move on to the special measures, including a private room in the secure side of the building, there's got to be a staff member with the individual during the day to move them, and so it's not an option that comes free of resource implications.
Is it made worse by the age and sometimes the condition of a lot of our court buildings that the family courts have to use?
Sure it is, because they weren't built for this.
Because that is a problem, isn't it?
Yes. And the Lady Chief Justice gave evidence to you, and she and I and the other senior judges, we want to move away from a system that simply puts elastoplasts on the buildings, and we want a long-term view on what sort of court system we want. It goes back to what I was saying at the beginning, the court of the future, and for there to be planning with the vision to achieve whatever that long-term solution is. To live day by day is not an easy world to live in if you're trying to work in the buildings. But there's a limit to what I as a judge should properly say to you as politicians on the spending of money. But I think that would be my
certainly from the practical operations of the court. If it's getting to a stage where the operation of the court is made harder by the condition of the buildings, that's a legitimate concern for you to raise with us.
Yes, no. At any one day, there are buildings where the lifts don't work, or there's a leak, or the power's off, because they're buildings that have seen their time, some of them.
That's helpful. Mr. Allen.
Yes, thank you, Chair. Sir Andrew, according to CAS data, in 2017-18 there were 103 applications for deprivation of liberty orders. That increased to 579 in 2021. Why do you believe those applications have increased so significantly in recent years?
So these are, to help the committee and anyone watching, these cases relate often to teenagers, sometimes to younger, but teenagers who need to have a level of protection from themselves and for others to be protected from them, and it's decided that their liberty should be restricted in some way. The statutory scheme for achieving that is through the making of a secure accommodation order under Section 25 of the Children Act. The secure estate, as it's called, this is the state-run premises to provide secure accommodation, are of a limited number, and they're very oversubscribed. I think the figure is around 60 or 70 young people every day are being put forward for what may be no or one or two beds in the secure estate. So that's the situation on the ground. If they can't be the subject of a secure accommodation order, then there's a need for some different authorisation for them to be restrained. And so they come to the High Court, which exercises its inherent jurisdiction to authorise deprivation of liberty, DOLS, orders, in the way that it might do separately under the Mental Capacity Act for an adult. And we've, over the course of the last 10 years, been undertaking those sorts of cases in greater numbers. And your question is, why have the numbers gone up? I'm getting round to the question now. I think the cohort of young people that we're seeing has changed. Some of these young people, not a lot of them, but some of them are victims of county lines and serious organised crime, and hitherto they might have been banged up in the criminal justice system, but they're seen as victims. Local authorities take care proceedings to protect them, but they've got to be put somewhere that stops them going back to the gang and protects them as best it can from being contacted by the gang. So those young people are there. They've always been troubled youngsters, and it splits almost precisely the gender 50-50. They're not all boys, they're not all girls, who are very mixed up and may self-harm or cause harm to others. It's out of control. The proportion of those, or the number of those, has gone up. I think life is very complicated if you're a youngster who having trouble staying on the rails now, and drugs and alcohol are available to you, and all sorts of other relationships that you can get into online make life more complicated. I think also there's a proportion of youngsters who might hitherto have been in the mental health service, in child and adolescent mental health, who aren't, but need to be contained. So I think my take is it's a slow creep of different factors coming in. It's something that I have, and other judges in the family division have spoken of publicly in judgments, because we feel it's inherently unsatisfactory. We are operating this jurisdiction because we take the view that we have to for the protection of children, but we're doing it knowing that Parliament has set up a different scheme, and we're operating without Parliament considering what we're doing. So I would be very comfortable in Parliament at some stage having a look at this. Also, separately, now this is the end of the answer, it's a long rambling answer, I'm afraid, there's legitimate public concern, and certainly concern of the judges, as to the accommodation that these young people have to be put in, because often it's ad hoc arrangements which are organised by a commercial agency, often for commercial benefit of a high order. The fees that are charged for looking after a youngster are very high, and they come out of the local authorities' budget. Ofsted wish to, understandably, have a duty to ensure that all children's homes are regulated. Often these unregistered places that we have to use don't want to be regulated. Regulation comes with a whole range of requirements that some of these organisers of care don't want to submit to, and it's a I always get confused which is a buyer's market and a seller's market, but because they're often the only resource available, the child has to be put with them. And so what I'm to give you, in the case that I particularly gave a judgment in, which was called Re-X, involved a youngster who's now soon to be 17, and I went up to visit her in the accommodation she was in last July, and it was a house on a housing estate in a Midland industrial town next door to everyone else living in the area, but with 4 carers on a rota with her in the house, and she wasn't allowed out because she would do a runner and wasn't safe, and she was there week in, week out in that accommodation. So the whole thing seems to me and to those other judges dealing with it highly unsatisfactory, to put it in the most neutral of terms. And so I've raised this in judgments. I've had meetings with government, and it's been taken up, as I understand it, across government now, the DFE, Department of Health, and the MOJ, to look at what can be done about this. And the review of care that Josh McAllister undertook covered this as well. So I don't think I'm speaking out of turn as a judge in raising this, because it is, when I became president, I said it's the top of the list of things that worry me, and as I sit here 6 years on, it's still the top of the list of things that worry me.
Would it be the case that High Court is being used to gap fill because of inadequate resources?
Well, you might say that, and we do what we're asked to do because it's necessary, and of course we do it. And the volume is high. We've had to establish a whole listing process, and we have 2 judges full-time every working day dealing with the new cases that come in, and then they go through. So resources, whether it's gap filling, I'm calling out what we're doing, and in the hope that if it is a matter of concern, it will be taken up.
Can you explain what circumstances led you to create the National Dolls List?
But it was
the second part of that be is what impact it's having on how dolls applications are handled.
That's a helpful question. That the again for new listeners, as it were, until 2 years ago, these applications for deprivation of liberty would be issued in the local court for the local authority where the child was being looked after, and they'd pop up in the list of the local judge. It could only be heard by a judge authorised to sit in the High Court, and that judge typically would be very busy doing cases, and these cases come in on an afternoon out of the blue, and they take an hour or two. So that was unsatisfactory. Also, our system wasn't able to count them, so we didn't know how many there were in the country, and so I decided to bring them all into London and establish what we wrongly called the Dolls Court first off, so that a local authority anywhere in England and Wales who wants to apply for a deprivation of liberty authorisation has to issue it in the Royal Courts of Justice. That now is heard in the Dolls List by one of these 2 judges who sit there, and that's been good because it relieves the sudden unplanned case popping up in the local court. B, it gives us a chance to count them and enables you to give the statistic that you gave. What we were doing when we set it up was we were holding on to the cases in London all the time, but that's not satisfactory, because if they're going to carry on and come back every 3 or 4 weeks or so, they need to have the same judge, and because the rota of judges in London was changing, you couldn't get the same judge. And also the young person often, as I did in Re-Ex, often wants to meet the judge and feel that that's their judge. And so what we now do is, if the case has got longevity, it goes back to the local court in a planned way. So that's what we're doing, and that's why we did it.
Can you share your reflections on the transparency pilot, which was rolled out to 16 more courts in January?
Yeah. I think, as I said in the introductory words, that it's been a positive experience. You'll recall that when I started it, I did so with a report after a review, and I said it had been in the too difficult box for a long time, because it is. You've got to be sufficiently open to give the public, through the press, confidence in what the courts are doing on behalf of the public, but at the same time maintain the confidentiality of the parties. And this is a genuine pilot, and I've always been plain at every turn that if I was given evidence that the confidentiality of the children, particularly, but the parties in these cases, was being breached, then I'd stop it.
How have families reacted to the cases being reported, albeit anonymously?
I'm in various, but we haven't got a feedback from every family. Anecdotally, hearing the Sancha Berg and the BBC team sat for some weeks up in Leeds and produced a report on 5 different cases, one each morning, on the Today programme in the autumn. And in 2 or 3 of those, the parents were really pleased that the press had highlighted what was going on in their case. The mother in the case that led to Harriet Harman's amendment was on the radio last week saying, "I'm really glad this had happened." Equally, I've had reports of parents being really uneasy that the press are there and this is a private case. What I'm also told is once the case gets going, that unease subsides. You get used to the journalist in the room. So it's, as it should be, a mixed set of reactions.
Are you aware of any instances of people being identified via jigsaw identification?
I haven't.
Or otherwise as a result?
I haven't, and I'm pretty sure that I would be told about that, because that's the real worry. I think the journalists, of course, they're on their best behaviour because they know this is a pilot and they want to get it right. But equally, my experience, I undertook a long set of hearings involving the ruler of Dubai, where 15 or 20 journalists sat in to every hearing, but were subject to strict reporting conditions, hearing a story which was very reportable, and they abided by the rules very strictly. So I am quite taken by the professionalism of journalists, and equally they don't want to be on the wrong end of contempt of court proceedings. So at the moment they've stuck to the rules about identification, and it hasn't happened. But one is constantly wary about that, and we'll have to deal with it if it comes to pass that there has been. And in the modern world, simply not putting someone's name in the report doesn't avoid, as your question indicates, the potential for them to be identified through the jigsaw methods.
And has the pilot helped mitigate the problems caused by the chilling effect of Section 12 of Administration of Justice Act 1960?
I think it's too. We haven't. It's the disappointment with the pilot is that there aren't a lot of journalists, and they haven't been coming in great numbers to the court. So I think it would be wrong for me to use what anecdote I have to say that it has or hasn't.
What further steps need to be taken to enhance transparency? For example, is work underway to make the courts list more informative?
That is a question at the root of the difficulties we've got. At the moment, the court list simply has some meaningless number, and you can't tell whether the case is about one topic or another, whether it's going to last 5 minutes or 4 days. We have developed a system of basic letters to put on the court list, which will identify to journalists roughly what category of case it is. But that's no more than a make-do. I encourage judges, if they have a case coming into their list which is of genuine public interest, to alert the local media about it, and that seems to me a perfectly tenable way forward. Equally, the rules have changed, and parties to a case can talk to journalists now and tell them about it. It always used to be that a lot of press reporting about the family court was after the event, where an aggrieved parent went to speak to one or other of the journalists who regularly ran stories about this to say this was awful, this happened 3 weeks ago. Whereas now, if they're worried, they can go before, and the journalists would be welcome in court. More generally, as I've said a number of times in other settings, there's much more to transparency than simply the journalists coming in. Simply being more open, me sitting here talking like this, local judges having a sensible relationship with the local media, us producing more and more authoritative data about what we do. We've got a group working on that, and judges producing anonymised judgments of ordinary cases, not the top flight football stars or whatever it might be, but just what happens on a wet Tuesday afternoon in Sheffield or whatever it might be, will add bit by bit to the public awareness of what we do. So all of these things are being progressed. Thank you.
Can I just come in on the point that you were making about not having received complaints about jigsaw identification? Yes. How would a participant in proceedings know who to complain to?
They go to go back to the judge who was hearing the case. That's what they would. They wouldn't come to me.
And how would they know that they should do that?
Well, they would, because the judge will have made the order saying, do not report this, that and the other. The order has, sorry, keep the micro. The order has failed in the example you were putting forward to achieve confidentiality. So the litigant goes back to the judge who made the order.
I just want to establish at what point would the litigant be informed of that? So how would they know who to complain to?
I don't know, so perhaps we ought to make that explicit. And that's what instinctively, certainly if they were represented, they would do.
We heard that many of them are litigants in person. I just wanted
so,
around the transparency.
I think that's a good point. Though those who are more directly involved with the pilot may be saying, why doesn't he say this? But I haven't got the answer to that. I don't think we expressly, in ordinary terms, say, if there's a problem, come back and do this.
It just strikes me that so far, journalists and legal bloggers have behaved themselves.
Yes.
And I just wanted to understand that first person who does
well,
not
I'll
behave
take
themselves.
I'll take that away. I think it's a very good point.
We talked a bit earlier about judges, and at the beginning, Sir Andrew, you referred to the concerns that judges have, which legitimately you've raised. One of the issues is shortfall of judges, of course, isn't it? Not just in the family division, but it is quite marked in the family division as it is in some other jurisdictions as well, particularly at the district judge level. Am I right?
It is. It's also it's geographically pronounced in the southeast, more pronounced in the southeast, and it's at district judge level.
And that's where the bulk of the family work is done, really, isn't it, by the district judges?
Yes, and the magistrates.
Yeah.
And there's a need that legal advisors to the magistrates. That's an existential post. If you haven't got a legal advisor, they can't sit. And there are difficulties in maintaining. We train them up. It's a good training, but quite a lot leave. So it's not just judges; it's legal advisors.
Lord Burnett, when he was Chief Justice, I think in his last report, referred to the district bench continuing to struggle to attract the numbers needed. Is that still the case? As far
It
as
is.
family?
It is. There hasn't really. It's only been a short time, and there hasn't really been a change in that.
On the other hand, it seems much easier to recruit part-time judges, the fee-paid judges, as we call them, the deputy DJs, than it is to get people to sit salaried full-time. Yes. In the family context, the Lady Chief Justice, Lady Baroness Carr, gave us some thoughts as to why that might be generally. Is there anything in the family context that
I think
it's
the same. The district judges sit in civil and family, and it's so we're dealing about with the same people. And I think what the Lady Chief Justice said was right. Being a fee-paid judge is relatively attractive. It's flexible. You only need to work when you're prepared to work. You get travelling expenses to the court. If you're
carry on your practice.
You can carry on with your practice. If you're salaried, you don't get travel expenses to the court. You get a pension entitlement now as a fee-paid judge, so I can see why there isn't a great incentive.
Do you think that the particular intensity and sometimes emotional pressure of the work that's done in the family court is a factor as well? And I've been very struck, if I may say, when I've visited the family courts with the calmness with which your colleagues have to deal with some very testing, personally difficult issues for the parties.
Yes, I think coping with that element of work, which is particular to family, or certainly more striking in family, is something that family lawyers and family judges take on as part of their professional skill to deal with. But it is pressured, and obviously being a full-time judge, you're exposed to it full time. Something that is happening more and more, and it's certainly very welcome, is people becoming salaried judges, but starting at least on a part-time basis, and that has led to the demographic of the district bench and the circuit bench moving to quite a younger generation
yes,
who,
yeah.
for lifestyle reasons,
Yeah.
choose to have a steady job rather than being a barrister or solicitor when they've got childcare. And so I think that's a good song to sing in terms of people joining up on a part-time basis, and that also gives some alleviation from the stress that would be the case if you were 100% employed.
I think the current split is roughly 2 to 1 in family. 60, I think it's 64 figures I saw, 66% to 34% full-time salaries against fee paid. Does that make sense to you?
These statistics, I think I saw one that was
the other way around.
75-25, but
Yeah, okay.
but it maybe.
I know the Lady Chief Justice talked in terms of 80-20 as
Yes, well, that
ideal.
seems to be right to me.
And that would work for family as well.
Yes, yes.
Yeah, I get that.
But partly, and I think this is more particularly important in family, judicial continuity.
Yes.
It's quite in both public law and private law to have the same judge every time you pop up in court is very helpful. And not to is unhelpful.
And that's a problem at the moment.
Well, I think if you've got part-time judges, it's then that you've got to rebook the same person.
Slots, and they may not be available.
Yeah.
So that's the advantage of more salary.
Yeah.
I can see that. And just finally, in the family division of the High Court judge, you've about 19, I think, High Court judges in your division. They're dealing with some of the most complex and challenging.
Yes.
Well, literally life or death in some cases.
Yes.
In terms of what has to be done. Are you concerned about retention or risk of burnout of your judges dealing with that really serious and draining work?
Well, I'm certainly concerned, as all leadership judges are, with well-being, and different individuals can cope with different pressures in their own way, and at different time in their own home circumstances contribute. So I'm aware of that. I'm not aware particularly of burnout, which puts it in quite graphic terms, but it is pressured, and something we haven't spoken about, and is that the family judges, or some of them, also undertake all the work in the Court of Protection.
Yes.
And so the higher end welfare issues in the Court of Protection, which do often result in life and death decisions, come up to the High Court level. So that's not an insignificant part of the work.
That's a significant burden.
Yeah.
And do you anticipate any difficulty in recruitment trends going forward? Have you
No,
got any retirements coming up at that level? Or?
With the movement that we're looking, it's a matter of public record, we've got a competition, as these things are called, being run by the Judicial Appointments Commission at the moment, and we're looking for at least 3, if not 4, new judges to start in the autumn. But I'm confident that we'll get.
That's good. The final thought, particularly back to the district level, we had quite a lot of evidence from the Association of District Judges about the impact of LASPO, frankly.
Yes.
The fact that there are now far more people appearing in person.
Yes.
And I think one quite graphically said, well, in the old days, before that, when there was legal aid, I could list about 10 cases in a day.
Yes, no, I read that.
And does that ring true to you?
Yes, it does.
Yeah.
And it's not that litigants in person are deliberately making it, but they're new to the experience, and
just takes longer.
Yes, and there's also there's no professional that the judge can turn to say, "Will you draft up the order?"
Exactly. Yeah.
In this case, so it all falls back.
Judges are having to draft up orders, which they weren't having to do in the past, on top of hearing the case.
Yes.
Yeah, thanks. Ms. Next.
Can I just ask a quick question around? You mentioned geography, particular shortages in London and the South East. What about by gender?
Don't think it. I think I haven't got the figures, but I would suspect that the family judges are, if anything, the preponderance is to be women.
I suspect you're right. Could you ask me whether there's been any work done to understand how retention of women is supported?
I don't know. I can reply.
I think it would be interesting. We know in many sectors post-COVID, women over 50 were opting for the great retirement. I just wondered whether that had also been the case in family law.
That's not my. I get to know when people retire, and I haven't. The retirements that have happened recently have been people who coming to the ordinary end of they've done their full stint. I'll ask about that. I just don't know, and it would be a proper thing to ask about.
Indeed.
Thank you.
And if there is any material, if there are any
Yes,
do by all means write to us, and then
very,
we can
very kind.
publish that along with the rest of the evidence. That's very helpful. Thank you, Dr. Mullen.
Thank you.
Yes.
So, Andrew, I wanted to ask about potential opportunities for the judiciary to learn from historical decisions, both individuals and as a cohort that you make. And the inquiry is prompted by a constituent of mine who had an experience of being involved in care proceedings and having a local authority and other family members attempt to persuade the court not to return a child to the custody of some other individuals.
Right.
And the court ultimately decided that they would make that return of custody, and consequential to that decision, the child suffered serious and irreparable harm. And of course, I wouldn't expect you to comment on an individual case in any way, shape or form, but I met with that lady and she observed, I think quite fairly, that she noticed that everybody else involved in that decision was subjected to quite a thorough process of reflecting on the decision and how it might have been dealt with differently, etc. And she genuinely asked me, I don't know, what happens with the judge, so to speak. And it got me thinking about the grey area, I suppose, between legally justifiable decisions. So, you know, you might quite rightly say, well, if people are unhappy with a decision, they could legally challenge it. But of course, there are decisions that might be legally justifiable, but perhaps were not the wisest decision to take. And so I wrote to the Lady Chief Justice about this issue and seeking just to understand really what the process is, what reflection the judiciary might undertake in these sorts of cases, and wasn't really given anything tangible that I thought would demonstrate, as I said, taking up opportunities to learn and reflect. So the first thing I wanted to ask really is just what is the mandatory training that someone who ends up as a family court judge making these incredibly serious and consequential decisions will have typically undertaken to help them in that role?
So this is care proceedings. They go on it's a 5-day residential course, whether or not they have any experience in family law or not. They then have a mentor judge that they sit in with. I think it's for a week, it may be longer, but that mentor judge is available to them in the short to medium term, and then they start sitting. They are then brought back for a continuation course, which is two days. There's no overnight residential course every 2 years. The Judicial College in the meantime...
2 days every 2 years?
2 days every 2. The Judicial College, in the meantime, sends regular bulletins, updates. There's online training to access and the like. And so it's a continuing process of exposure to the issues. They will be sitting at a court centre where there will be other experienced heads, other judges with more experience available, and it is, as you will anticipate, the norm for judges who've got a tricky decision to go and knock on the door of the judge next door or to ask the others about it in some other way. So it is very supported as an experience, although the judge on the day is on his or her own sitting in the courtroom.
And can you shed any light on whether there is any more structured process for asking judges to reflect or learn if, as I said, they've made decisions that might be legally sound but had consequences that they would probably personally themselves agree they wish hadn't transpired?
Well, I think your constituent asks a perfectly proper and astute question. You will know that when a tragedy happens, there has to be a serious case review. I think they're called something different now, but I'm so long in the tooth I call them still serious case reviews. And that is where all the agencies will come together and they will meet and talk. This is an issue as to whether the judge should be sitting around that table and should be questioned about what the judge has decided, has been raised formally over the years, and the Judicial response is always that the judges are for them to maintain their independence of their decision-making role. They shouldn't be subject to an audit after the event, and so the judiciary and the court will provide as much documentation to assist the serious case review, but the judge speaks through his or her judgment and should, and normally will have done, will have explained their reasons for doing what they did do, which has turned out to be a decision with tragic consequences, if that's the case. So that's where the line's drawn, and that's where we maintain it. If that needs to be looked at, it needs to be looked at. But that's
I'd be interested in your views. Do you think
answer.
that's an entirely satisfactory scenario?
Informally, you couldn't be a judge involved in something like that and not hear about it without yourself thinking about it. Judges don't live in a sealed box, and so I know nothing about the case you're talking about, but as a professional and as a human being, you would obviously reflect. But because of the need to allow judges to make their decision independent of any further scrutiny, formal scrutiny, other than by the Court of Appeal, that's where the line is drawn.
Do you think if that's a hard and fast rule that you can't even be involved in a discussion about what you may or may not have done externally, do you think at the very least the judiciary itself could establish its own procedures for ensuring, you've said obviously and you would expect, but actually I couldn't tell my constituent, and no MP could, that the judge did necessarily sit down and read the serious case review? We wouldn't even be able to say that definitely happened.
No, well, I think you couldn't, you couldn't, because you wouldn't know, and it's part of there's a priority to be attached to judicial independence, which is part of the overall priority attaching to the rule of law, and that the judges aren't answerable to Parliament for their decisions, to MPs for their decisions, to constituents for their decisions, and in the same way that the integrity in terms of confidentiality about judicial training is maintained, there wouldn't be a formal process whereby you or your constituent could be told, yes, the judge has been subject to some internal process within the judiciary.
So you think that it would reach judicial independence for the judiciary itself to have a process internally?
No, what I'm saying is it would be a breach of judicial independence for you to be entitled to know
whether or not
yes, but of course if there is an established procedure, you don't, it's a procedure the judiciary agrees will happen. That's different to saying, did this judge in this case do this, yes or no? You could just have a process. I mean, do you think it's entirely satisfactory that there is, at the minute, no formal process at all to review, potentially...
I haven't said that. I'm just saying that it's not something that the judiciary will be publicly giving an account of.
And you think that's, because the judiciary... We're today talking about the fact that as you advocated, that we're increasing the transparency so that people can sit and watch cases and the media rather have... Do you think that's defendable in the long term to say, well, you can know nothing, the public, about how we react to cases where serious harm comes?
Well, I think you raise a significant constitutional issue. I think you've said you're in touch with the Lady Chief Justice. I think this is more properly dealt with by her, rather than me.
She hasn't chosen to engage with me on it, unfortunately.
Rather than
I think we've probably gone as far as we can.
Okay. Well, the second point...
me responding. It's not for me to sit here without any warning on this question and respond on behalf of the judiciary. And what I would say, as my own personal view, is of no value. So I think it's. I'm not saying you're raising something that shouldn't be raised, but I think there are different channels where it ought to be pursued, where it can be looked at with reflection.
Okay. I'll go on to ask some questions about data, which again I think IT and data that you mentioned earlier. So the government's recently announced its plan to kind of push back the completion deadline for the private law portal. The public law portal seems to be kind of moving ahead with greater success. What do you think has been different in how the two projects have been rolled out and led to perhaps different outcomes in that regard?
Ironically, I think it's partly the way that it was done. The public law portal was an early product of this reform programme at a time when the model was called we're working in an agile environment, so it would be rolled out before it was properly ready and then worked on while people got to grips with it. And that wasn't a very healing process in terms of those working with it. It's come good in the end, and that most people are comfortable with it now. But it was decided that the private law programme would only come out when it was match fit and ready for action. And it's turned out, unfortunately, to have more technical difficulties than was thought. So I think that's why. It was always going to come out later. I'm not technical, and the public law programme involves more parties and more formal stages. Private law, 2 parties normally, and it's fairly straightforward. So I don't understand that it's more complicated.
Okay.
But I suspect there's technical issues that are way beyond me.
And what's the feedback that you've had from court staff and advocates on court visits, for example, on the new portals and online tools?
Well, it's settled down. With any change, this is, I think, at its time, certainly it was said to be the biggest change project being undertaken across government. And it was being visited upon people working really, really hard in a court system with cases every day. And so the reaction of staff and judges initially was negative, despite the fact we all absolutely positively welcome the change. I mean, I visited a judge in another jurisdiction last week because they're still working on paper, and that judge's room was full of
people were supportive in principle, but
paper files. So the idea that we should be moving to a digital system is obvious,
yes.
And I'm very pro it. And now that the systems are working, I think most judges would say they can see the benefit of it. The financial remedy side doesn't work so well. The public law side works well. The divorce system works with alacrity.
Okay. And then just on data collection, you've talked before about the need, and even in this session, for data. What progress do you think has been made on data collection in family law cases?
We've commissioned research to work out what we can get, and that research hasn't come back yet. The hope is that the new computer systems will count in a far more sophisticated way what's happening in the cases, and that's the hope. So at the moment you chance upon me at a time of hope rather than realisation.
Okay, and I think you've previously spoken positively about the Nuffield Family Justice Observatory. I wonder if you could just share what impact you think that's having and what we might learn for it for wider data.
Yes, it's
issues.
Before the Nuffield Family Justice Observatory was established, there was nothing. Occasionally, academics might report on some aspect of family justice, but there was nobody focused on A, doing that, but B, being willing to do it at the request of the system. And the Nuffield Foundation provided the funding, and the individuals, Lisa Harker and her team at the observatory, are admirable. They are very flexible, they're very insightful, and they were of enormous value in COVID. I was able to ask them, I think in the April, to report about remote hearings and how they were being experienced, and they reported very quickly. I can go on for ages. The scope of what they've done, in particular, identifying how we deal with babies who are born into care, has been of a real insight, and that's giving rise to the court and the local authority, aided by the Nuffield in Blackpool, looking to establish a problem-solving court called the Baby Court, which may be inevitably a variant of FDAC, that sort of approach. And so time and time again, they have been of enormous value.
Is there anywhere in particular you think they could look at next that they might be able to make a contribution?
I don't know what they are. I think I'd need notice of that. I can't think that they're normally ahead of me.
Okay, thanks. That's been very helpful, Sir Andrew. We've dealt with quite a lot of ground there, so I appreciate that. Sort of as a wrap-up, going forward, the rest of your time as President, are there any particular priorities? Are there, to use your phrase in Re-X, anything else that needs to be called out? Any other problems that should be called out in the family justice system? Or you want to?
The priority has got to be the rolling out of Pathfinder to every court. It seems to me impossible now we've established that we've got this wholly different model, which is better but also more efficient and saving resources, that isn't rolled out. So my shoulder is going to be at the wheel of rolling Pathfinder out as we go forward over the next. The ambition is to get it out to as many places over the next year. I'm also keen to continue the transparency developments. I'm also keen on FDAC being available in every area to the postcode lottery at the moment, and it's
more of that problem-solving approach.
More the problem-solving approach, and I think the more we can get into that mindset, the more we move away from litigant-driven family cases to cases that focus on solving the problem.
Thank you very much, Andrew. That's been very, very clear.
Well, thank you.
Very helpful. Thank you for your time and for your evidence. Session is concluded. Order.
The proceeding has ended. 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 The proceeding has ended.